If you have questions, I think there will still be time for questions at the end because the afternoon might go a little bit quicker, I guess. If you need the morning certificate, we have more of those. If you have not signed in for the afternoon session, you will have to sign in. As you all know, or I don't know, many of the new attorneys may not know, the state bar kind of has you on the honor system. You sign in, you say you went. People here have been audited many times. We keep a record. So if you want to get a certificate, get it. But if we don't have a record of it and they audit you, then that's your ass because we won't back you up if we don't have a record of it, okay? So please make sure that you are being accountable. You sign in, you get a certificate when you've been present for the training. All right? Okay, John, I think we're ready. Okay, wait, I don't know if you can do that.
And clearly cursing is not an issue with us.
Oh, right.
So who's new? Who wasn't here this morning? Anybody? One, two, just a couple? Did you guys like get some petitions dismissed this morning or what? No? Did you just submit, go straight to a 2-6 or what? All right, well, we'll skip the formalities. I'm Kevin, this is Jim, as far as we'll go with introductions. So this morning we covered direct, lay witness direct, and expert direct. This afternoon we're going to do cross. I am fully aware that lunchtime, the period of time immediately following lunch, is the shittiest time of the day to sit down and listen to somebody talk. So, sorry. But let me know if you all, if I see heads start bobbing and eyes closing, we'll do some I don't know, some conference room yoga or something. Get the blood flowing. There used to be Red Bulls back there. I don't know if they all got sucked down, but there might be Red Bulls, and there's the Hercules of Keurig machines next door for coffee. Get caffeinated, do what you got to do. Shameless plug. At the end of this thing, I'm going to try to get you guys to follow my Facebook page, my Instagram, my YouTube, and all that crap. So in that vein, I want to rock a selfie with me and Jim and all you guys in the background. Since this is shameless self-promotion. So you guys got to do something though. You got to give me a little like on the count of 3, like a little woo, like you're going on a roller coaster. 1, 2, 3. Woo! Awesome. We got the back of your head. So thank you for that. Housekeeping stuff, I think we're good. After Jim does the talk on cross-exam, we're going to do another drill, get you guys up a little bit, and then get into expert cross. Just like this morning for the new people, don't be afraid if you have questions, raise your hand. We are cool to break up the monotony with some questions. It's fine. So, without further ado, I saw a flyer on the door in there, so John, this is for you.
Thanks. Okay, we're going to cover expert cross-examination. The cross-examination first. Before I get started, a couple of remarks here. I didn't realize there were so many new attorneys. That's great. What a cool job. It may not feel like a cool job some days, I get it, but you know, you're in the courtroom, you're standing, you're representing people who needs representation more than these parents, and you know, you're doing it. I clerked at a civil defense firm when I was in law school, and I figured that's where I'd end up. But these guys never saw the inside of a courtroom, ever. The most exciting thing they did was depositions. And you guys are doing it. You're in court. You're making opening statements. You're making closing statements. Over here, not too many openings here. But you're cross-examining, you're direct examination. So, I mean, what great experience, and also great client control. I mean, if you don't have client control in this job, you're going to get steamrolled real quick. And just really great experience. And you know, Kevin included a form in here on public speaking, and just a couple things. A lot of it's complex. One of my first dependency trials I won was a woman who had her 2 children taken away because she was basically having drug, sex, and kegers every weekend. And social workers didn't look too kindly on that. It was a little wild at the house, and so they filed a B petition. And given it was preponderance of the evidence, we submitted on jurisdiction, but I challenged the disposition of removing them because they're older children. And I won. And they got placed, I won my trial on Friday, and they got placed home. And I was really happy with myself, and it felt like I had really done some good, and a real confidence booster. Unfortunately, between Friday and Monday, Mom decided to celebrate with a sex, drugs, kegger party at her home. So, easy come, easy go. Out they were Monday morning. I guess it's job security. But, you know, it's confidence. You can do this, the younger lawyers. There is no magical litigation, drug, or character. You're looking at someone who, in college, was absolutely terrified of public speaking. Sweats, out-of-body experiences, nerves, jitters, shakes, you name it, I had it. And you know, it's just through repetition, getting up there, standing up there, and doing it. And do it. You are better than what you think you are. We can be our own critics, worst critics. I haven't done a trial yet where I haven't learned something. And just keep plugging at it. I really encourage you to, because you can do it. And just real quick on nerves. You know, you are going to have nerves, and you know. But one thing I learned, and I tell my interns, we have a big intern program in San Diego, and some of the younger lawyers, is you hear an opening statement by county counsel or by the district attorney, just basically trashing your client, just taking it to them. And you know what helped me get through my nerves was thinking, you know what, I can either get up, stand up, and fight for my client, or I could walk out the door. I don't have to be here. I mean, I have a job tomorrow, but I don't have to be here. And you hear that, and you're like, no, you know what, enough already. You know, Kevin played my cousin Vinny, and one of the best parts of that movie is Vinny's opening statement. After the district attorney gives their opening statement, he gets up and he tells the judge, everything that guy just said is bullshit. And I've always wanted to do that. And, here's another disclaimer though. If you don't remember, just like my witnesses, anything I told you during this training today, I am not suggesting you get up on Monday morning or Wednesday and get up and say, everything that county counsel said is bullshit. Don't do that. So that's for the supervisors. But if you do, call me. I want to come up and I want to see what that looks like. But you can do it. And so I digress a little bit, but you just plugging at it. Keep plugging at it. You get better at it every time. I'm still getting better at this job. So you do important work, and your clients need a voice. So, all right, cross-examination, how to give them a voice and what to do. Okay. Okay, this is completely different than what we talked about this morning. Everything is different in cross-examination than direct examination. You're questioning the opposing party's witness, and there's a totally different way. How we did the who, what, where, when, whys, all gone. Not during cross, okay? It's used by both sides in civil and criminal cases. And a lot of times, my cases are not all that great, where I don't have witnesses to call. And it may be what we call a reasonable doubt case. If the district attorney can't prove their case beyond a reasonable doubt. In dependency, the agency can't prove by a preponderance of the evidence that they can sustain the petition, or by clear and convincing that the children should be removed. And so a lot of times it is based on cross-examinations. And you can win trials on cross-examination. I have won trials on strictly on cross-examination. So it's the most common way for defense attorneys a lot of times, because we don't have the witnesses. And that's okay, because we get to tear apart their case. And if we do it correctly, and we're prepared, and we've gone through their reports, we can do it. You can be successful. It is in no way, just because you don't have a witness, you can't win your case. Okay, you are the director of a direct examination, and the witness is the star. In cross-examination, this is different. You're the star. You're the one testifying. In direct examination, I stand back and I let my witness shine. Can you please explain that? Can you elaborate on that? they're shining. On direct cross-examination, I'm in control. I'm only asking questions I know the answer to. I am only asking questions I know the answer to. If there's a real quick way for your trial to go down the tubes real quick, start asking questions where you have no idea where your witness is going to go. So, I use the reports. I go through the social workers' reports. I go through the jurisdiction dispositional reports. I go through the 2-6 reports. I go through the 6-12-month review, the dreaded additional informations that come in the day before trial in San Diego County. I don't know if you get those here, but they're pretty brutal. You do? Yeah. That's another way to sideline a trial. But you're prepared. You know the answers because the social worker's given you all the answers in her report. And you know what questions to ask. You know that she didn't talk to, your clients. I had a case that the social worker just did so little in researching and investigating what my client had done. My client had done some additional things outside her service plan. And she didn't talk to some of the providers in the service plan. And we went through, all these omissions. And, it just basically tore apart the foundation for her conclusion. Kevin and I talked this morning about opinions. Well, opinion is only good as what it's built on. And if you got a social worker who didn't bother talking to your client's parenting class instructor, or anger management instructor, or a drug counselor, sometimes they do, you'd be surprised, sometimes they don't, then you're starting to erode that foundation. It's not worth the paper it's printed on. And so what you want to do then at this point is you are in command and you want to let the witness know you are in command, okay? It's not time for runaway witnesses, and we'll talk about that in a minute, but you are asking leading, short questions. We don't want them to slip away from our grasp. We know the answer to the questions. And if they give us a different answer, we have the reports here. We have them tagged. We have them however you want to do it in our outline. So we can say, well, ma'am, you stated in the 6-month review report that, that the mother, never went to any visits. And, you've got information where at another time she has stated she went to her visits regularly. So, but isn't it true? You submitted an additional information just before this trial. And in that report, you're sourcing back so you know the answer in case they slip away. That's preparation. So you are asking short yes or no questions. And you want to keep that witness in a cadence. And again, I know every jurisdiction, but I stand up. It's hard to be intimidating. And I want to explain. Cross-examination is not the bull just coming at the witness and going to him. You don't have to do that. You can get your point across without doing that. Sometimes you need to, but you need to stand up. That's just my practice. So I throw it out there. I know courtrooms are different and judges are different, but you want to ask these short yes or no questions. It's codified in 761 as far as cross-examination and what the scope is. You can go into a number of things. You can go into credibility of a witness, such as bias, motive. If you have a family member testifying about the horrible things that your client did, there may be, through your investigation, you may find out that there's a bias or a motive. You may find out that this witness is not really believable, and there's reasons. You can impeach them. Be creative. Look beyond the reports. Because if you put a witness on, if the county council puts a witness on the stand, anytime a witness gets on the stand, their credibility is at issue. And really, aren't we trying to tear them down as far as their credibility? And so doing those investigations, having that material to show, I know what the witness says, Your Honor, but this is why he or she can't be believed. Let's see here. All relevant evidence is admissible. So be creative. Get your investigation requests out there, and look to see what you can do to show that this witness is not credible. You already know where you're going with your case. You don't want to ask a question that doesn't support your theory, and I think this is in one of the slides coming up, but I'll mention it now. Cross-examination is not a rehashing of direct. And I think that's one of the biggest mistakes I made during my first couple dependency trials, is I would go up there and I'd start walking through the direct examination, and every once in a while pepper a question in there that I thought was important to highlight. That's not it. What you want to do is the direct examination, county counsel's going to get all the information out they want, and you know, there may be only 5 or 6 things or less that are important to you. You go straight to those matters. You focus on those. You know, ma'am, I want to ask you about what you saw on the visit on November 3rd. You know, those type, go straight to what you want to highlight, and tearing apart the credibility or pointing out observations that the social worker just kind of brushed over in her direct testimony. You know, maybe she wrote in a report how good the visits were, but just fails to neglect to testify about that on direct. You want to go right into that. Don't waste the judge's time walking through direct, because you're doing, again, because what you're doing is you're giving the social worker now, or the witness, another chance just to go out and throw more garbage against your client, more stuff that's damaging to your client's case. Go in, focus. What do I want to point out on cross-examination that's witnessed that supports my theory? And that's really where it should be. Don't feel like you have to do this pedestrian thing and start at the beginning and start at the end of direct examination. No, you can go right into it. Ma'am, I want to ask you about the visits on November 3rd. Isn't it true you were there and you observed those visits at that time? You were at the house about an hour, weren't you? No, that's what you want to focus on. So pinpoint where you're going with your cross-examination. Get in, get what you want, get your answers, and don't feel like you need to you definitely don't want to just rehash the direct. Organizing your cross. There is deconstructive and constructive cross-examination. Deconstructive cross-examination is when you're really kind of tearing down the witness, going after them. Constructive cross-examination, we like to do this in criminal a lot, and I like to do it in dependency, when I can get their expert to agree with some of my points. I mean, isn't that cool? I didn't, you know, in closing argument, I get to say, well, Your Honor, it wasn't my expert who said, not only my experts say that, but the agency's expert said the same thing. If you can get their witness to agree with some of the points that supports your theory, absolutely, get them to do it. That's very powerful, very powerful. It's powerful if you don't have your own expert. It's powerful if you do have your own expert. But getting their expert, constructive cross-examination, to concede some of the points you're making is really big in the case. So you want to look at both constructive and deconstructive. Deconstructive is going after that witness, attacking their credibility. Now remember, you want to look at the whole picture, and you want to see what this looks like, and it's not mutually exclusive. You can do both. I suggest to you, though, if you are going to do a constructive cross-examination, in other words, eliciting favorable testimony out of the agency's witness, you're probably going to want to do that first. Okay? A bad way to start is just to go after him and just destroy him on cross-examination and say, well, I'd also like to ask you about some other things that support my client's case. Not going to happen, right? So think about, that's the sequencing of cross-examination. Don't have to be cross on cross. And it's really true. A lot of times you can get what you want out. The way you look in front of a judge as well as a jury matters. We want credibility. And you don't have to be the bulldog in the courtroom. Sometimes you do. But if you can get what you need in a professional way, I think it's get your credibility points, judge or jury. So that's something to think about. There are some, especially some social workers and police officers who smell new blood. They see new attorneys and they're like, you know what, this guy's not going to walk me down anything. And they're going to give you a hard time. So I will start out after the first couple of questions with this evasive witness, or you know, we get this cocky cop on the stand who's really giving you a hard time. I'll start pretty hard and just kind of, you know, there's some techniques as far as when a witness doesn't answer. But sometimes you got to hit them on the nose with the newspaper early on and say, no, we're not doing this. So something to think about. Every case is different. Every witness is different. Primacy and recency. We touched on this in the lecture this morning. I like to start big and end big. right? Everyone's paying attention at the beginning and at the end. You signpost. We talk about this sit-down question. I will preface it sometimes with, Dr. Scrinovant, I want to ask you a few final questions. Everybody kind of perks up. All right, this is coming to an end. There must be something good coming here. So primacy and recency, primacy being the first, first and last thing, recency the first and last thing you hear tend to stick with judges and juries. And so think about that in organizing your cross-examination. And a good thing to remember is that if you have some facts that don't support your case, you kind of bury them in the middle. And you kind of slide them in, and that's a good place to put those things. And, again, credibility. You don't embrace your bad facts. They're not going to go away. The county council is going to bring them out. Let them out. Decide what you're going to do with it. Sometimes you just got to kind of own it. Other times we can turn lemons into lemonade. But it's part of the credibility and going through that. You don't want to let a judge or jury think that you're hiding the ball. Your bad evidence is there, you got to think of a way to deal with it. And sometimes it's easy, sometimes it's not. Sometimes it may be just accepting it, but minimizing it. Other times it may be kind of putting a spin on it, just seeing that it's different than what it was portrayed. But that's something to think about as well. But you probably don't want to start your cross-examination or direct examination with the worst facts in your case. Put that somewhere in the middle. You don't want the jury to remember that as the first thing, because they're going to, or your judge, because they're going to be paying attention, in the beginning and the end of an hour and a half cross-examination, or even a half hour. So something to think about organizing your cross. You do need to write out your questions. And this is what I do. I write out all my questions. I write out every single question because I need to see how it's going to flow. I need to see where I'm going with this. And then what I do is, maybe it's an awful lot of work, and I know a lot of you in dependency because of the caseloads are playing a lot of triage, and do what works best for your cases. But what I will then do is do an outline. And I will have an outline on a sheet of paper, and it will be Roman numerals on the areas I want to go to. And I have it up there and I glance at it. But what I do not want to do, and what I did when I first started out, which is kind of natural, was read my questions off my piece of paper. It interrupts your flow. It shows you don't have control. It's very scripted, but instead, and also what we talked about this morning, it makes it so you're not listening to the witness. You gotta listen to the witness. They'll give you all kinds of good stuff if you're listening, sometimes. So what I do is I have my outline, and I will just glance at it, and so it's a roadmap for me. But I've already written the questions. You guys know your cases. You've been through your cases. You've read the reports. You've prepped this thing up. It's all front-loaded, and rely on that. And you're not going to get lost, especially if you have a roadmap or an outline. But I really stress, and I know it's hard at first, but don't have your questions written out verbatim. You won't have that control and that focus. So it's just something to think about as far as techniques. How do you organize it? Well, there is a great book, and I just saw him speak this last summer by Larry Posner. He wrote a book on cross-examination, and it's excellent. If you have time, pick it up. I know sometimes it's available on Lexis or Westlaw, but it's worth reading. And what Mr. Posner basically, I just did a long training for our office on this because it's really that fundamental, is chapters. And what your chapters are is basically just your topics of what you want on cross-examination. You're going to talk about that visit on April 3rd. And what it is, the parent was very embracive. The child was running over the parent. The child leaped out of his seat and ran over to the parent, mom, as she walked in the door. Super important in 2-6 hearings when they say your client doesn't have a bond with the child. And you're going to organize that. And you start kind of with the general, and you go down to the specific. Start with your foundation. The social worker. You observed a visit on August 3rd. Isn't that true? Yes. And the mother was there. Yes. And she actually arrived early to the visit. Isn't that true? Yes. And the child was there. Yes. And Jason was present when my client. When the mother walked in the door, isn't that true? And when she walked in the door, Jason got off the couch immediately, yes. And when he got off the couch, he started to walk over to the mother, yes. In fact, he didn't even walk, he scrambled over the couch and towards the door where the mother is. What am I doing? I'm painting word pictures. And I've read the social worker's report, and she used the word scrambled. So when she says, or briskly ran over to the mother. So when she says, well, I wouldn't say it was brisk. Pick up your report. Well, ma'am, you wrote a report in this matter, didn't you? In your report, you want to be true and accurate because it can be used in a courtroom, like it is today. And in that report, you just saw the visit, and you described how Jason got off the couch and briskly, quote unquote, briskly ran towards the mother. Isn't that true? Yes, or I don't remember. Your Honor, can I approach? You know, you're using words out of the report to build up your cross-examination.
Can I jump in? So I put on here proof chart, and recognizing that this training is normally 30 days, and in the first day we do trial prep. One of the things I talk about is a proof chart. So I'll give you the real brief lowdown on creating a proof chart. You may not need to do it when the only witness you're crossing is a social worker, but for instance, if you have medical evidence, you're going to want to create a proof chart. Proof chart's super simple. You pick out the good facts that help prove your theory of the case. All right, in Jim's example, child scrambled towards mother. If that's a big deal in your case, you just make a chart, child scrambled to mother, visitation log of 11/30/17, page 9, line whatever. They're the highlights, the big deal facts, so that you have it all on one page. These are the things that you think your witness might conveniently forget, right? If they're big medical facts and you're crossing the other doctor, you know, the child was in no distress when he arrived at the emergency room. That may be a big deal, all right? So you have a proof chart, so if they say no, you're not this person at the... I know she said it, God. No, I look at my proof chart. You know, the medical records, page 38, line 9. Boom. And then we're going to get into impeachment later. But that's what a proof chart is, and that's what Jim's talking about. If the facts are important and you think you're going to have to reference them, write it down. Right? Super simple, one-page kind of thing.
Yeah, it's called sourcing. Sourcing the answer. So you know, I mean, yes, you're asking yes or no questions, but your witness may not answer just yes or no, or they may conveniently forget. Social workers tend to forget the good stuff that they observe. Instead, they only remember, you know, what they want to put in the report that says your client should no longer get services or that there's not a bond. And, you know, if you know where that answer is, you can go to it quickly. And guess what? You're telling that witness, again, you're in control. And they're going to be less invasive next time, the next couple of questions you ask for the rest of that direct examination, because they're saying, oh wow, this guy's got his shit together. He knows where this stuff is. And if I go start embellishing, he's going to catch me. And Kevin's right. I've done it when I was first started working on trials and doing dependency trials. I forget where stuff was, and I didn't have it sourced. So I'd be switching through, looking through papers. And it really doesn't look good in front of a jury, and it doesn't look good in front of a judge either, because it shows that you're kind of unprepared. So, you know, what I would do is I write out my question, and then at the end in brackets, you know, social worker 6 months review, page 2, paragraph 6. So when that social worker says that all of a sudden that the kid didn't scramble, you got it. And you can go right to it. And we'll go into impeachment. But it's super important that you know what the answer is and you know where to find it if they don't give you the answer that they've already basically admitted. Because you know the answer to the questions you're asking, else you wouldn't be asking them. That's sourcing. We'll talk about it. The do's across. Okay, ask leading questions only. I know there's always a tendency to stray from this. And we start to get a little overly confident, our shoulders go back a little bit, we're in control of this witness. and then we start going off script. And when I say going off script, it's not what we have written down here, but we start ignoring some of these rules, and that is you're giving the witness room to explain. You're giving the witness time to conditionalize their answers. And you won't get that with short, one fact per question questions. And they're really not so much questions as they are statements. And you know, you can ask a question, I think there's a slide up here on taglines in a minute. You can ask a question in a way where you don't have to say, isn't it true or correct, and you can do it by your voice inflection. Ma'am, the red was light. Don't say it like that. The light was red. The voice inflection shows that it's a question, and they're going to get used to that, and you're going to train them for that. Your witness, you are training your witness, and so you only want to ask leading questions, because once you stray from that, you're going to get in trouble, and you're going to get in trouble quickly, because now you've got a witness who's adding all these things that you don't want out. And we'll talk about witnesses who stray from that. Okay, here's the taglines I was referring to. The light was red, correct? I know that judges, particularly in bench trials, they're really aware of our tendencies. And, you know, after the 11th or 12th, correct, they're like, enough already. So I try to, light was red, wasn't it? I try to drop that, because it can be very repetitive and a bit irritating, especially when you're in front of the same judge all the time and they've seen you do many trials. So again, use of voice inflection. The light was red. Yes. So something to think about, just so you don't have the corrects. Wasn't it repetitive all the way through? Okay, only ask the do's across. Only ask one fact per questions. The reason you want to do that is a number of reasons. One, you'll get a compound objection. Wasn't the child scrambled off the couch and ran towards the mother, embracing her in her arms? That's not a good question. One, you want to break it down to each one. Jason got off the couch. He jumped off the couch. Yes. In fact, he got off to his feet. Yes. And he saw the mother. Yes. And he immediately scrambled towards her. Yes. So you're creating these word pictures, but you're also giving the social worker not a way to kind of slither out of the answer. It's real short questions, and you get into this cadence and this role, and you're training this witness that this is how the testimony is going to be, and this is how you're going to answer. So that's really important. Use clear and plain language. Again, really important to go through your reports very closely. And I, again, like to use words that they used in their report, whether it's a social worker or a police officer. If they say something was large, you don't want to say big. You want to use the word large. If they say scrambled, you don't want to say ran, because you're going to give them room to conditionalize and say, well, I wouldn't say that. I like to use words that support my theory of the case and use that in my cross-examination. Use clear and plain language, especially with some lay witnesses, also with experts too, for jury trials and bench trials. You don't want an expert talking above what everyone understands. I put an expert witness ID expert on early in my career, and he was talking about rods and cones and reflections and all this stuff. The jury had absolutely no idea what this guy was talking about. So I had to kind of back him down and kind of go, you know, doctor, you said rods and cones. Can you explain the purpose of that? What does that mean? You know, so the jury and the judge is relating to what the witness says, and they're not using words that they don't understand. Don't assume that your judge understands all the medical terms that your doctor may be using. Your doctor may be an expert in brain trauma, and he may be using all these cortex, frontal lobe, all these different and far more complex terms. Don't assume that your judge knows that, because he may not. And you know what? Take the time to have them explain that if you're doing a direct. So plain language is important. We stress this all the time. Listen to the answer the witness actually gives. You may think that they're going to give one answer. They may give something else. That's when you have to impeach. We're going to talk about that. But witnesses will give you something. And if they give you something that's good for your case, then you're going to want to use it. The social worker may say, yes, he scrambled over and fell into her arms. Well, that may not be in the report. She may not have said fell in the mother's arms. And you may, so then, now, ma'am, you just said that Jason fell into her arms. I want to ask you about that. You know, at what point, what did that look like? How did that happen? How did the mother react? You know, you're pretty safe in that territory because she's already committed that this child fell into the mother's arms and was scrambling over, excited to see her, those types of things. So if they give you something like that, don't be afraid to kind of go off script. And if it supports your theme, spend some time with it. So listening is really important. And I know it's hard because a lot of times we will ask a question and we're not listening to the answer, we're thinking about our next question. And through repetition, it will come. It will come. But listen to your witness. They may give you something that you really can use. Very basic. Don't ask a question you don't know the answer to. Just don't do it. I mean, you're just asking for trouble. And that's really the golden rule of cross-examination is you need to know the answer to the question because you may not like the answer. And, you know, it's really hard to clean that up. So if we stay with what we know the answers are going to be, we're in pretty safe territory, and we're in control. Again, here we go, looking at prior statements, know your case inside out. It's really preparation and going through those reports. Yes?
Do you think that bullet point applies as much in a bench trial scenario as it does in a jury trial scenario? So in terms of asking questions that you don't know the answer to, because I know that's something that's been hammered into us for forever, but I feel like so often in our system, most of the questions that I ask, I don't always know the answer to them. And a lot of the times I think that the golden nuggets that we get are like the open-ended questions in cross where they just respond and say something unexpected and helpful.
You know, that's a good point. You're taking a chance. If that witness is called by the other side, they're not here to help you.
I think the other issue too, with the bench trials, is that I've appeared before bench officers as well, where if you are doing your cross-examination based on the social workers' reports, they're going to say, "Counsel, I've read the report. Why are we going over this again?" And so I think that's like a distinction too, where we don't have kind of the flexibility to really develop and like massage these kind of facts out through cross-examination because the bench officer should theoretically have already read the reports.
They may have, okay, two-part question. With the bench or a jury, either way, that's your trier of fact. That's who's going to make the decisions in your case. So by asking the questions, you know, judges can get a little jaded, and you know, I'm sure they've heard it a million times, but you know, a bad answer is a bad answer is a bad answer, and you don't know the answer to the question. You may get something good, and you may not, and it's tough to take that chance because you're going out on that thin ice, and that's why I kind of really stress you get so much information in these reports or what your investigator has found out, and sticking with those answers that you know. Excuse me, those questions you know the answer to, you're really much on safer ground, and you know, it's just too much of a gamble to ask those open-ended questions. You know, you just never know what you're going to get, and it could really hurt your theme, and you can't go back. So it's a risk.
And you've got to have a theme. So if it's, you know, don't just ask questions for the sake of asking questions. If it's, you know, I don't know, an adjudication of whatever, you know, and you have a goal of, I'm attacking, you know, this element of the D petition, whatever it happens to be, and you have a goal, asking a question that you don't know the answer to can't, I mean, it's not going to get you to your goal if it's a 50-50 gamble that something's going to come out. I mean, you have to know what you're attacking. Now, there are some cases in dependency where it's just a fucking loser, right? It's a dead bang loser. You got nothing. Okay. But, I mean, if you have a theme and a theory to your case, and my goal is to attack this particular thing, then stick to that. You know, it's cross. You're not there to go fishing unless you've got nothing. You know, hopefully you have a theory and a goal in mind. That would be the only exception that I...
Yeah, I have seen trials going incredibly well, and cross-examinations I have gone incredibly well, and then I ask one question too many. I'll ask a conclusionary question. So Pam, isn't it true that the child did have a strong bond with the mother? After she talked about the running to the mother, the embracing the mother, Jason falling in her arms, and then I asked that conclusionary question. Well, isn't it true she did have a strong bond? No, that's not true. Let me tell you why. Boom, boom, boom. And, shit, you know.
Who's the...
If I motion to withdraw that last question and the answer.
Who's the famous lawyer that represented all the mob guys in...
Who was that?
Oh shit. Anybody help me out? You know what I'm talking about. Famous trial lawyer. It'll come to me.
Cutler. Bruce Cutler.
No, that's not what I'm thinking of.
No, not him.
But anyway, it'll come to me. He said about cross-examination, the best cross-examination is no questions, Your Honor. Right? So, you win cases on cross when you don't have your own evidence. Right? If you had your own evidence, you'd put it on. That's a good case. All right, when you're stuck with nothing, you're going down that road with cross. And you may have something on cross. You may have something that you can poke holes in on the other side. But you don't want to go fishing on cross because you're gonna get bit. You know, it's the thing to take away from cross-examination is this is dangerous.
Yeah, and I think, you know, you might get something good. You might really get something good. And there's a tendency, we can't help ourselves sometimes. We're doing real well, we're feeling pretty good, but boy, it's a risk that we don't need to take, and it could go really bad too. And it's just not a real good idea. You know, and Kevin brings up a point. You know, they may have a number of witnesses. Oh, I know a lot of times it's just a social worker, but they may have a number of witnesses. If some witness doesn't hurt your case, no questions, Your Honor, on cross. That's sending a message. That's sending a message. You're not here to waste the judge's time by just asking questions to be asking questions. It also shows that you have a theme, and you have a direction, and you know where you're going with it. And that can be very strong too, powerful. So don't ask questions if you don't need to. Usually there are questions to ask, but don't feel like you have to. Next one, do's and don'ts across. Don't ask the one question too many. So
this is the duck, guys. This one's easy. You know, we have Jim here. This is Jim. You can tell by the dapper outfit he has on. So if I was going to cross-examine Jim, I'd say, Jim, isn't it true you're white? Jim, isn't it true you're white?
Yes.
And you're covered with feathers.
Yes.
You got a yellow bill.
Yes.
You eat little fish.
Yes.
Sometimes you eat insects.
Yes.
You got webbed feet.
Yes.
You like water?
Yes.
You float around on water?
Yes.
The way you swim is you kick your little feet under the water?
Yes.
No feathers on your feet though, right?
No.
The question I don't ask is, Jim, isn't it true you're a duck? Because he's going to go, well, I'm a swan, I have some swan on my mother's side. And no. If he walks like a duck and talks like a duck, then he's a duck. And you go to closing argument and you say, Your Honor, he's got white feathers, he's got little feet, and he kicks under the water, and he eats fish with his bill, and he's a freaking duck. Right? But you don't ask Jim, isn't it true you're a duck? Right? That's the one question too many.
You know, I think in Kevin's example kind of tied in everything we've been talking about in cross-examination, or at least since the break here in cross-examination. What did he do? He asked me short questions. He asked me questions he knew the answer to. And what did I do? Yes. Yes. No. I had nowhere to go. You know, if that's me, I can't say I don't have a bill. I can't say I don't have webbed feet. I can't say I don't have feathers. He's asking short questions. And he got me in a rhythm. I don't even like to be in a rhythm. I do cross-examination. I don't want anybody controlling me. I'm an attorney. We like to talk. But I had nowhere to go. And that's what you want out of your witness on cross-examination. The other thing is that one question too many. With your social workers in the 2-6 trials, if the issue was bonding and you want to ask those questions on bonding, you are going with the visits that the social worker observed that were very beneficial, that were very helpful. That on July 3rd, Ms. Smith, you social worker, you were at a visit and you saw Jason. When he saw the mother, he leaped off the couch. In fact, he not only leaped off the couch, he ran towards her. And then you went back to a visit, you observed a visit a week later. And on that visit, Jason was playing with toys. Isn't that true? Yes. And when he was playing with toys, the mother walked in the door. And you were correct? Yes. And you were there. You were present. You witnessed this. Yes. In fact, you were there before the mother arrived. Isn't that true? Yes. And now when he saw the mother, he immediately put his toys away. Yes. And he looked at her and ran. He looked at her, correct? Yes. And he ran towards her. Yes. And when he got to her, he opened his arms, didn't he? Yes. And when he kept those arms open until he hit her, correct? And when he hit her, he embraced her, correct? And when he embraced her, he put his arms all the way around her. Isn't that true? Yes. And he didn't let go for at least a minute. You know this because if they described it in the report. Now, you don't always get that much. But if it's there, you use it. Now, you were at a visit 2 weeks later. And Jason was also at that time playing with another little boy. Yes. Yes, he was. And the mother came in. Yes. And he saw the mother. Yes. You observed this. Yes. And on that visit, he stopped what he was doing. Yes. And he got up and ran towards her. Yes. And on that visit, he put his arms around her. Yes. And then on July 5th, you watched such visits. So I'm going through all these visits where I'm showing that the child and the mother do have this strong bond. But what I am not asking is, and so isn't it true, Ms. Social Worker, that the mother and the child have a very strong bond? Well, no, it isn't. And then now I'm screwed because I asked that one question too many. So I've set up all those, and then what I'm going to do in closing argument is I'm going to then make that point where the social worker can't disagree with me, can't conditionalize what she saw, can't explain her answers. She's long gone. It's closing argument time. Yes?
So, assuming you're asking these short, leading questions and the social worker then tries to embellish, how do you stop that? It's like, yes, but...
Yeah, we've got a slide coming up, but I'll talk about it real quick. There's all kinds of ways to deal with the runaway witness. In fact, I think Kevin's going to talk about it. There's the hand. A lot of times putting out a hand, we'll do it. A lot of times that they may ask something and you may repeat the question. Ma'am, I ask you, didn't Jason put his arms out towards her? Well, yes, but ma'am, Jason put his arms out towards her when he saw her. Well, yes, but, ma'am, Jason, are you saying he didn't put out his arms? Well, no, he did. Thank you. There's ways to, and Kevin will touch on that, but that's to answer your question. So you're saving it for closing argument, because what are you going to do? You're going to get up and you're going to closing argument. You're going to say, Your Honor, there is no question my client has a strong bond with Jason. And how do we know that? Well, the testimony from their own witness, from the social worker, was that on July 3rd he did this. On July 7th, when she came back, he did this. On July 8th, he did this. And because of all those things, it is painfully obvious to see that Jason is very bonded with my client, with the mother. And that's where you use it, because now the social worker can't come up and say why that's wrong. So you're saving that, you're getting what you need on the record, you're making real-time impressions for the judge, so he's noting all these great visits and these bonds, this evidence of a bond, but you're arguing the bond in argument. You're saving it for them. So don't get yourself into one question too many, get the information you need out on the record. Credibility. Okay, there's a number of ways where you can take on a witness if they don't go the direction you want. The social worker, Jason got off the couch and he scrambled towards the mother. Well, I wouldn't say he scrambled. Well, Now you got to step back, because you already know the answer. Because you know on page 7 of her 2-6 report, she wrote, scramble. So, well, ma'am, you wrote a report in this matter, isn't that true? And you wrote a report, and in your report, you want to be put in true and accurate information. Isn't that true? Yes. And so you want to be as complete as possible. Yes. And you know those reports can be used in a courtroom, don't you? Yes. And you know they can be used in a trial, can't you? Can't they? Yes. In fact, a trial like this one here. Isn't that true? Yes. Now, in that report, you wrote about the July 7th visit, didn't you? Yes. And in that report, you made notations of what the visit was like, didn't you? And in fact, you wrote in that report, Jason scrambled towards the mother. Isn't that true? Two things are going to happen. Either she's going to say yes, because now you're doing stuff too, because you're picking up the report off the table, and you've got it in your hands, so she knows I'm screwed. This guy has my answer right here. So you've got it here. Or she's going to say, I don't remember. Refreshing recollection. Your Honor, may I reproach? The record reflect, I'm showing the social worker, her 2-6 report on page 7. So that's impeachment. Contradiction with other witnesses. What other witnesses say? Contradiction with common sense. Bias. These are all ways that you can cross-examine and attack the credibility of a witness.
And if I can jump in, I wanted to put all these in here because I don't want you to get caught up with the scope of direct too much. All right? You're only allowed to cross within the scope of direct with a couple of exceptions, and this is one of them. Okay? So you can always cross on matters affecting the credibility of the witness. Okay? You don't need that door to be opened on direct.
Yeah, and that's really important. And, you know, as I said earlier, just remember this simple rule as far as where you can go on cross-examination. You're going to cross-examine on the things that are in a report, his or her report, to support your theory of the case. But whenever a witness, here's the rule, whenever a witness takes the stand, their credibility is at issue. Whenever a witness takes the stand, you can attack their credibility. It doesn't matter if they testify for 2 minutes or 2 hours. And you can bring out all of this stuff. You don't have to, if someone has felony convictions, say you have a lay witness that the county council calls. They have felony convictions, they may or may not bring out those felony convictions. They may to take out the sting so they don't look like they're putting up a witness that isn't quite what they're supposed to be. But you don't have to have them open the door. You can do it. Now, Mr. Jones, you just testified in this matter. I want to ask you about some prior convictions you've had. You can do that. And because all of this, for the most part, is attacking their credibility. So, you know, get your investigator out there. Have them look at reports. Have them look at criminal history, civil history. Look at every civil filings, family law, restraining orders, you know, divorce records. It's great to come in and testify, an ex-spouse. I mean, that's good stuff. So, you know, all that stuff is credibility, so don't feel like you have to stay within the parameters of what what a witness said on direct. You can go beyond that, and that's getting on cross-examination on credibility.
All right. We're a little bit behind, so I'm going to do this relatively fast. We're going to do a freeze frame drill. So, I need everybody to stand up. Come on. Get the blood flowing. Oh, is that a volunteer? No, we can stretch. Get a good stretch. This is conference room yoga. Is anybody a yogi? Can we actually do it? I'm not, clearly. Can I get 5 volunteers that did not come up the first time? If you weren't here in the morning, you're automatically volunteered. So I know this guy. Who else? There was a guy back there. He's dressed nice because he went to court today. Come on up. Sell him out. You know who he is. Send him up. Come on. Who was it? Oh, it was you? I thought there was a guy back there. Wasn't there a guy too? All right, come on. Is he hiding? Is he trying to get out of it? Come on. All right, everybody else can sit down. So, this drill is called the freeze frame drill. So we're going to do this like a conga line, like we did the first time. For those of you that weren't here in the morning, that means you are aligned, you equal one extremely competent lawyer. You're going to ask first question, go to the end of the line, then you're going to ask second question, go to the end of the line, and so on. So, this is the freeze frame drill. So what I want you to do is I'm going to say, this is LA, it's Hollywood, you guys know this. We're going to have like a, take one, right? And that's going to start the clock. I want you to pay attention to what I do because you all are going to cross-examine me on it. All right? So you should watch. I'll go this way because I won't get in trouble for assaulting Jim. So, Jim's wondering what the hell's about to happen. So watch me. Ready? And take one. I want you all to be able to see too. So let me start over. Take one. And so that's it. How long did that take? Was that 5 seconds? 5 seconds?
Yeah.
All right. That is a 5-second scene. I am your witness. I would like you to cross-examine me on what just took place. We are going to focus on using leading questions, short questions, one fact per question. Okay? If you ask me, isn't it true you just threw your pen at Jim? You are fired. You have to leave. Okay? The point of this should become clear to you. When you have something in your case that is small but very important, we want to draw attention to it. We want to focus on it. You want your judge to think about it for a long time. You want to blow it up. Okay? You don't want to say, did you just throw your pen at Jim? All right? So I want this to be a minimum of 15 questions. All right? So if you ask me a bad question, I'm going to tell you no, ask a different one. So, you're first.
Isn't it true that you were in the legal conference room on February 27th?
Too many questions. That's tons of facts, man. I can wiggle around. I can say no, because one little part of that might not be true. One fact per question, and I got nowhere to wiggle.
You were outside eating lunch, so you weren't here all the time. They'll do everything.
All right. Isn't it true you were in Monterey Park on February 27th,
Yep.
2019?
Yes.
And isn't it true that you were giving a lecture at legal office
Okay.
that day?
Yes. Now, get to where I said go, not what happened this morning or anything like that. Step on up, you're next.
You had a pen in your jacket, correct?
Yes.
Isn't it true that you raised your hand back before you...
Not yet. No. No more isn't it trues.
You used your right hand to grab the pen.
I didn't get there yet. What did I do before that? Come on, break it up. Give me something sooner. What did I do before I grabbed the pen? That's like 3 questions.
You clapped your hands together.
Sure. Yes.
And you looked around the room, right?
Yes.
And you saw this gentleman, right? John?
That dastardly. Yes.
And then you walked to the left side of the room.
Yes.
And you clicked open your pen.
Not yet, but give me something sooner. What did I do? How did I get it in my hand?
You
What
took
did
it
my
out
arm
of your
do?
sleeve.
What did my arm do?
You took the pen out of your
Now,
jacket.
what did my arm do?
You reached into your jacket.
Close enough.
Your pen was in your breast pocket.
Yes.
And you grabbed the pen out of your breast pocket. with your
One at
finger.
a time. One at a time. I grabbed the pen.
The pen out of
That
your...
it? Yep. I grabbed the pen.
And
Next.
you pulled the pen out?
Yep.
And then you looked at Mr. McMahon, correct?
Yes.
And you clicked on the pen.
Yes. I want to make sure it does some damage.
You pulled your arm back.
Yes.
And you threw the pen in his
Not
direction.
yet.
And you smirked at him.
Ah, yes. It probably.
And you threw your arm forward.
Yes.
You threw your arm with force, correct?
Lots of force.
Let go of the pen.
And then I let go. Yes.
The pen spun in the air.
Yes.
And it went into the direction of this gentleman.
Yes.
And it hit Jim, correct?
Yes.
It hit him on his leg, correct?
Yes.
And you smirked when you saw it hit.
In joy and glee. Yes. Okay. So you get it. Thank you. Thank you. So the takeaways here are: if you put more than one fact, you give your witness the chance to wiggle out. Okay? Don't give them wiggle room. Very short one-fact questions. If you have something that happened and it's important, even if it was very short, something that took 5 seconds, you could turn that into 20 questions. Okay? That's what the freeze frame drill.
That may be the theme of your case. That may be one of the most important things. Is, you know, if I'm doing a self-defense case and I'm on trial for assaulting Kevin, you know, I'm going to argue self-defense and I'm going to argue what happened before then. So even though that took maybe 5 seconds, I'm going to elongate that. If I just say, you know, Mr. Lemieux, I'm cross-examining him, you threw the pen at Jim, over, done, that's not getting you anywhere. What do you want to do? Mr. Lemieux, you were in the same room as Jim. You saw him. You looked over at him. You squinted your eyes.
Yeah, those things where you guys were joking about how I looked at him, that could be real.
Oh, that's great. That's good stuff. You looked at him, you stared at him. And then what you did next is you started to reach into your pocket. And you reached into your pocket and you grabbed a pen. And when you grab that pen, and he's going, yes, yes, because I'm asking one fact per question. And when you grab that pen, you clicked it open. And you clicked it open and the point came out. And you did that before you threw the pen. And then you grabbed the pen and you brought your hand back. You not only brought your hand back, you brought it back past your shoulder. Now, I'm not going to ask, and you brought it past your shoulder so you could throw it harder. You can say that in closing argument. You got your hand back. And when your hand was back, you stared at Jim. And as your hand started coming forward, you continued looking at Jim, and you thrust that pen through the air. And in fact, that pen flew with the point open towards Jim. Yes. And it hit him. Yes. In fact, it hit him. It didn't fly past him. It hit him in the arm. You know, you're going to want to develop that. And I think we did a smaller version of this about Jason on the couch and the social worker. You know, there may be something brief about that visit. And there may be, in your report, there may be 20 visits where Jason ignored him, but the mother. But sometimes that's all you got. I mean, these 2-6 hearings can be really tough. But if that's all you got, you want to elongate that. So when, you know, it's not enough to say, well, when Jason saw the mother, he got off the couch and scrambled towards her. You're going to want to, or he scrambled towards her at the visit. You're going to want to elongate that and make that longer. And that's what you get to do in closing argument. Your Honor, someone who doesn't have a bond, a child doesn't have a bond, isn't going to get off the couch, isn't going to look at the mother, isn't going to push away his toys, isn't going to run over towards her. And you're using that example. That may be all you got, but you want to elongate that. And you're really missing an opportunity to say, well, on July 3rd, Jason ran towards the mother. Isn't that true? And then moving on. You're going to want to paint that word picture, and you're going to want to develop it. And that's the whole exercise with the pen.
Okay. So, we're going to move on to difficult witnesses. Goes along with your question. All right. And refreshing and impeaching. These are the skills of control. Controlling your witness. Reiterate, for you two that weren't here, or more that weren't here, stand up in trial. Okay, stand up. Control your witnesses. Rule number 1, good questions give good answers. If you're sitting there thinking, man, this witness just doesn't answer, I'm supposed to be asking yes or no questions, and I'm just getting these long, terrible answers, you're probably asking bad questions. Right? We call that garbage in, garbage out. If you're asking crap questions, you get crap answers. If you're asking short, one fact questions, it's hard for them to wiggle. And when they do wiggle on those questions, it's blatantly obvious who's cheating here. Right? If you have a jury, they're going to see it. And if you have the judge is going to know. If I ask you a simple one fact question, you have feathers. And you go, well, yeah. You know, we know who's playing games and who's not. So, good questions give good answers. Yeah. Good pace, precise language. These are how you maintain control of the witness, all right? Also standing up, looking them in the eyes, letting them know, I'm here, I'm asking the questions. Sometimes you get that witness, we tell you drop the taglines, drop the isn't it true, and corrects. You weren't a gray sweater.
Yes.
Now every now and then, you get somebody, you go, you weren't a gray sweater, and they'll just sit there. And then some smart ass will say, oh, I'm sorry, counsel, was that a question? You know, you get that smart ass answer, you go, yeah, that's how this works. I'm the lawyer, I ask you questions, you answer the question. You know, you're wearing a gray sweater. And if you have to throw a tagline in every now and then to train, you're training this person, right? And on cross, they're not there to help you. A lot of times they're there to purposely mess with you. So control, get up, stand in front of them, tell them you're wearing a gray sweater.
I say it's more light charcoal.
Now, something like that, yeah, okay, I'll go with that. But we want to train the person to say yes to our questions. Short, simple.
There's an example of the witness kind of messing with you.
Yeah.
You can see, okay, light charcoal.
Yep.
Fair enough? Gray light charcoal, isn't that fair? You know.
Yeah.
Because then the judge is like, this guy can't even answer a question about his gray sweater or charcoal sweater. Really?
And we're going to talk about impeachment. You want to pick your battles, right? There are certain things like that's not worth fighting over, okay? But there are certain things that are. You got to know. Don't fight with them over dumb stuff.
Shrug your shoulders. Okay,
So-
light charcoal. Fair enough. Can I ask my next question? You know, and you're just going to see that the witness is just playing with you, and the judge is going to. They're not going to like that. They want to get in and out. Give me the facts. You know, just answer the questions.
And now this is your question
Good example.
earlier, the yeah but witness. You know, the child ran towards the mother, or the child scrambled towards the mother. Yeah, but blah, 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 blah. Now there's numerous techniques you can do for the yeah but witness. I'll tell you my personal favorites. My personal favorites are, she says yeah but and starts rambling on. I let her ramble. This is one of the advantages of standing up. I'll walk over here, I'll turn my back to it. Kind of like, you know, projecting there. Are you done now? Can we move on? Right? It's obvious if you're asking good questions who's being evasive. That's the key. I mean, drive it home. Ask good, short, one-fact questions. So there's the, yeah, but blah, 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 ramble, and I go, okay, so that's a yes. He scrambled to the mother. That's one way you can do it. The re-ask technique is what Jim was doing. You know, you can reason with the witness. That tends to get you in trouble when you try to argue back and forth about their little nuances. You know, you want to eliminate their nuances. You don't want to reason with them. You can do the hand of God. She says, yeah, if I'm here, I'm in front of my witness. And he starts rambling on. I do that all the time. I do it. I generally, to be completely honest with you, I do it with two hands. I pretty much go, whoa.
It's amazing how simple it is, and it works.
And people will look at you like you slapped them across the face. You know, they'll be saying, no. They'll look at you and go, okay. What I'm asking you is this. Or you'll hear Joe Pesci, what I'm asking you is, you know, so it's fine to do that. I don't like to interrupt the witness. You can interrupt the witness, like verbally. No, mister, you know, I don't like that. I'd rather turn my back and let them blather on about whatever, and then go back to it. I call this the ask mom for help technique, Your Honor. I'm asking really short, one fact, fair questions, and he's totally not answering. I don't like that technique either.
Most times they're going to just say, Your Honor, you instruct the witness to answer the question. He is answering the question, counsel.
Yeah. So it's up to you. This is your trial. It's up to you. So if you get non-responsive answers, move to strike. You know, objection, non-responsive, move to strike. And I look at it like, you know, I'm just trying to get us all out of here, and this guy's wasting all of our time. You know, Your Honor, objection, non-responsive, move to strike, everything after yes. And if you don't get it, you can ask again. All right, sir. And I'll say things, I'll throw myself under the bus even though everybody knows it's not me. Sir, I don't think we're on the same page here. Maybe I'm saying it wrong. I'm very sorry. I'm going to try this one more time. You have white feathers, right? I mean, you know, but everybody knows. And if there's a jury, they're going to be like, boy, that guy's a nice guy. He's so patient with that witness who's an ass. It's really obvious. You get in trouble when your questions suck. And he says, and he wiggles around, but you had 3 facts in your question, so how can you take, you know, you got no beef with his bad answer, right? Because you don't even know what he's saying no to. So, the stop sign or the hand of God, ask it again. Let them ramble on. Those are my techniques. Question?
In your experience, is it ever helpful just to let the witness know, hey, I'm just looking for a yes or no here?
Yes, but people take this too far. So people will instruct the witness, when I ask you a yes or no answer, or a yes or no question, you have to give me just a yes or no answer. That's bullshit. That ain't true. So don't do that. It makes you look like you don't know what you're talking, because you can't enforce that. So if I were the witness and I was messing with you, I would make sure that every one of my answers had an additional word or 2 in it, just to prove that you don't know what you're talking about. You could try to ask them, but I don't know.
And that's why asking the one short question, fact per question is so helpful, because they can't wiggle out of it. I mean, the light was green. Officers, isn't that true? You know, yes. You know, if you ask that the light was green and there was a lot of traffic, well, I wouldn't say there was a lot of traffic. I mean, they can wiggle out of that, but the light was green, and if they say, yeah, the light was green, but there was cars all over the place. That's not what I ask you. The light, and I slow down, and sometimes I'll lean over the podium, although I don't like to stand in front of a podium, but the light was green. Yes, slow it down, re-ask it. And if they're still evasive, then you can also use this technique. Officer was saying the light wasn't green? Well, you know the answer, because he said the light was green here. Well, no, that's not what I'm saying. Okay, the light was green, correct? You know, training them right away. If they're going to give you a hard time, you might as well start training them right up front. And then say, this is not the way this cross-examination is going to go. I'm in charge, and I'm going to be asking these questions, and keep them short, keep them tight.
That's also why you generally don't attack on cross, unless you have to at all. And if you're gonna, you do it at the end, right? So that's difficult witnesses. Interrupting the witness, as I said, avoid it, be careful. Don't talk over them. The judge is gonna yell at you. You're the one who knows that we have a court reporter here, Madam Counsel. She's writing down everything you say. How many times have you heard that condescending speech from the bench? So I'm going to need you to wait and talk. Don't talk until she's done talking. You know. Let the witness look foolish. That's my walk away. Like, oh my God, here we go again. You know, it's fine. Here's the. Anybody have military experience? Use a measured and proportional response. So, isn't your sweater gray? And he says it's light charcoal. You know, I'm not going to sweat that. But when he wiggles out of the light is green, then you go after him. So this is largely a style issue. If it makes you really uncomfortable to do the double stop sign, whoa, don't do it. You know, this is a style thing. You're going to have to figure out what works for you. I'm just trying to tell you the things that generally don't work for anybody, and that's things like interrupting the witness, okay, or arguing with them about their answer not answering your question, right? Just go back to your question. Find your voice, it takes time, practice, self-awareness, all that jazz. You guys know that. Okay, refreshing recollection. Now, this is a different kind of witness. This is not necessarily the yeah, but I'm being difficult type of witness. This is just somebody who forgot something. This happens a lot. So don't freak out when this happens, okay? It's no big deal. Remain calm. Ask them. If they don't remember, you know, and this could be on direct or cross. There are times to use it on cross. Not every forgetful moment or bad answer on cross is time for impeachment. Okay? If you know this is just a mistake, I asked you, did this happen on Wednesday? And you go, no, it happened on Thursday. If it don't really matter, just move on. If it matters a little bit and you think they just got the day wrong, you sure it was Thursday? You know, you want to put some doubt in their head. Get them to say, oh, maybe I'm not sure. And you go, ha-ha, that's the buzzword you're looking for. Then you can ask them, what would help you remember? Don't ever say, what would help refresh your recollection? That's like, hello, ma'am, I paid a lot of money for my law degree and I'd like to use big words now. That's not how human beings talk to each other. We say, what would help you remember? Right? Especially if you're in a jury trial. They're going, what the hell is everybody talking about? You forgot. What's going to help you remember? That's how you talk in trial. All right? You can suggest things. The basic method, you could say, hey, would your report help? Your addendum report of 1022? You know, whatever. They're allowed to look at it, give it back. Obviously, 702, the evidence code. They have to testify from memory, so they can't read it on the record. They have to look at it. And we play the fictional game of, I forgot. Oh, now I independently remember. And I can testify from memory. Okay? We all know it's a hoax, but they're not allowed to read nonetheless. You can use anything. There was that what is that stupid case in law school? You can refresh someone's recollection with a ham sandwich or whatever it was. Yeah. So, obviously, the previous statement is best. This is a real simple deal. Basically, you're asking, would your report help you remember? Yes. You say, Your Honor, may I approach? You take the report, you get it to the correct page. Your Honor, may the record reflect I'm showing opposing counsel. Opposing counsel gets to see it. Okay? May I approach? Yes. Give it to them. Please look at that. You can tell them it's right there. You know, read that. Just put it down when you're finished. All right, thank you. You come back. Don't say, has your recollection been refreshed? Now do you remember?
I do.
All right. And it was, what day was it?
It was Thursday.
It was Thursday. Whatever. This is an important note. I'll get to you in 1 second. Do not refresh your witness with your own notes. I mean, you can. But then you get to go over county counsel. You want to see what I think is important in this case? Right? County counsel gets to see everything that you use to refresh. Where was the question? Yes?
So what do you do when you have like the, I'll call her the I don't remember witness who's, you know, is just like feigning forgetfulness on every single question. They knew everything on direct, but now that it's crossed, then sort of everything is, I don't remember. And then even if you refresh, they still just for everything. I mean,
well,
how do you like handle that?
Depending on what you're using to refresh, don't worry, I'm not going to turn this into an evidence section, but you can get into past recollection recorded where you actually lay a foundation for the thing, and you can have them read from it, things like that. You can turn it into an impeachment if you think they're lying. But, you know, sometimes you're just going to have to refresh it 20 times, I don't know. But I think in that kind of situation, the way you describe it, it's pretty obvious that they're screwing with you.
The judge is going to get impatient with that. And
yeah.
You know, after the 5th time you've walked up, Your Honor, may I approach again? You know, having the witness come back. You know, and don't be afraid of wild, weird answers, such as, I had an officer, a police officer once, I said, well, officer, we're reading your report that helped refresh your recollection. No. So I just paused, again, using silence. No. So let me get this straight, officer. Are you telling me that what you wrote down in this incident, in your own report, that's not going to help you refresh your recollection? No. I looked at my jury. Okay. I got it in another way. In closing argument, how fun was that? This officer couldn't even, all of a sudden he couldn't even remember his own words. And his report, he said his report. This guy's not credible, ladies and gentlemen. I mean, you can have a lot of fun with that. In the other example, as far as the witness who just can't remember, remembers everything on direct examination, but on cross-examination, just, you know, memory erased, can't remember anything. You know, human nature is funny. People don't like to be corrected over and over. And I can say with a relative amount of certainty that most witnesses, after about the 5th time walking back up there, okay, we can do this again. We can do this all day if we want. But you're going to answer the way that I say you're going to answer. The judge is going to get impatient. You watch the body language. He's going to start going like the judge, like this. The witness is going to see it. They'll start perking up.
Yeah.
Will it always happen? No. Most of the time, though. So you'll get them.
And you get to comment on that in closing.
That's a gift.
You know, this is their star witness couldn't remember anything. How can you rely on their statements they made, you know, over here, but with me, they couldn't remember any of the details of that day.
And I've used that in closing
Absolutely.
argument. It's just like, you want to talk about bias, ladies and gentlemen? When Mr. Smith was on direct testimony, everything that the district attorney asked him, he couldn't recall. But when I asked him even the most simple question, like what color sweater he was wearing, just simple things, all of a sudden he couldn't remember. Ladies and gentlemen, that is not a witness that you can trust. That is not a trustworthy witness. And you know, it's really a gift, taking those things and really use them to your advantage.
And in a bench trial, your judge is going to get there on their own.
Big time.
Right. So, impeachment by prior inconsistent statement. This is the flip side of refreshing. This is adversarial. This is like, what makes you feel good? This is like, I'm a lawyer and I'm about to wreck somebody. Use of the adverse witness is common method of impeaching a witness. It's not what you said before. That's what impeachment is. It's saying, you're playing games with me. This isn't what you said before. I'm going to nail you. I'm going to make you look silly. Okay? That's impeachment. Make sure this is a real inconsistency. All right? The sweater's gray. The sweater's light charcoal. I'm not going to impeach over that. When you impeach over petty shit, it makes you look petty. So don't be petty. Impeachment is like weapons of mass destruction. You know, take that thing out with care and caution, but when you use it, explode it on somebody. Question, is impeachment hearsay? No. Impeachment is an exception to hearsay. So if it's coming in for its truth, that's different. It's coming in just whatever you're doing here, the prior statement, the prior inconsistent statement, is coming in for purposes of impeachment only. That's an exception. So, there are 3 C's. Impeachment is so easy. I've boiled this down to 3 words, and it's so easy. It becomes mechanical when you've done it a bunch of times. All right, we're going to do a conga line of this too because it's just repetition. And if you can do it a few times, it's like laying foundation for an exhibit. People get super nervous about it, but when you've done 10 of them, you're nervous as hell. All 10, and on the 11th one, it's like boom, 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 boom. You know the formula. Impeachment's the same way. 3 C's: confirm, credit, and confront. So we confirm what they just said, we credit the prior statement, and we confront them with the discrepancy. The way that looks like is, confirm. Did you say on direct exam that the light was red? No, here, I put it down here. Show the jury you don't believe it. Be incredulous. At this point, I like this word. I usually try to have an incredulity contest. But did you say the light was red? Like, are you kidding me? That's how you're going to confirm their prior statement. Sometimes that's all you need. And you go, oh, no, I meant green. Well, that's what I thought. So we confirm the present statement. Did you just say on direct exam that the light was green? Really? Okay. Confirm. Check. Show the judge and the jury that you don't believe them. That sets it up. Now everybody knows where you're going. Oh, he's pissed, right? He doesn't believe any of this. Now we're going to credit the prior statement. Okay, we're not crediting this statement they just made. We're crediting that out-of-court statement. This is super important. An impeachment is only as powerful as the prior statement is credible. Now, impeachment, there's a couple of different ways to do impeachment. Impeachment by prior inconsistent statement is like the stereotypical impeachment. It's the fun one. But in all honesty, it doesn't happen all that much in dependency. For the main reason that you guys don't have depositions. That's the main time that prior inconsistent statement comes up, when there's a depo. It could come up in a police report. something like that. But you have to make sure that the prior statement is credible. All right, so that prior statement can't be some double hearsay nonsense that you can't really credit, right? When we credit the prior statement, we do it like the freeze frame drill. Taking something small and we're pointing out how really important it is, okay? You want to point out things like oath or other formalities. The timing of the statement. When you said that last time, that was closer in time to the event actually happening than it is today. You want to point that out. Then when you confront, you maintain control. You do not let the witness talk. The way I do it is, I will say, Your Honor, may I approach? Show to opposing counsel, and I approach, and I will say, did I write it in there? Please follow along as I read on line 3. It says the light was red. Isn't that what it says right there? I don't say, will you read it? Because they might go, yeah, that ain't right. That's not what I said that day. That's wiggle room. No wiggle room. Isn't that what it says right there? The light was red. That's what it says right there? Yeah, we all know the answer. Right? So, I'm going to let you guys see this. Give you an example. Let's do this. This is, and I know you don't get depots, but this will make it easy. This is a depot of 11/3/17. The light was red. End of depot. This took a long time. Signature. Okay? We're going to pretend it's your signature.
Okay.
All right? This is all we do. So this is my prior inconsistent statement. The light was red. Deposition dated 11/3/17. Signed by what's your name?
Chris.
Chris. Signed by Chris. All right. And I'm going to say, because Chris just changed, Chris on direct just said the light was green. So I'm incredulous. Did you just testify on direct exam that the light was green?
I did, yeah.
Okay, so I've confirmed it. Now I know I'm in attack mode. Oh, good. Credit the prior statement. I'm going to say, Mr. Chris, do you remember giving a deposition in this case?
Yes.
That deposition took place on November 3rd, 2017.
Yes.
Took place in my office.
Yes.
You came to my office that day with your lawyer.
Yes.
We did this deposition in my conference room.
Yes.
I was there.
Yes.
Your lawyer was there.
Yes.
There was a court reporter there. See, one fact. The court reporter asked you to raise your right hand before the deposition.
Yes.
And she had you swear to tell the truth.
Yes.
The whole truth.
Yes.
And nothing but the truth.
Yes.
And you did.
I did.
Right. And you gave a deposition that day.
Yes.
You answered a question that I asked you that day.
Yes.
And then when the deposition was over, you received a copy of that deposition transcript.
Yes.
And you were afforded an opportunity to make changes.
Yes.
And you had to sign that deposition transcript.
Yes.
And after you signed it, you returned it to your lawyer, right?
Yes.
Okay. Details. Now, you want to identify this for the record? Your Honor, I have the deposition dated 11/3. May the record reflect that I'm showing it to opposing counsel. Yes, the record may so reflect. Your Honor, may I approach? And I'll go up and I'll say, Mr. Chris, would you follow along with me right here? Would you agree that that says the light was red?
Yes.
Okay. That's it. You don't say, and were you telling the truth then or are you telling the truth now? When did you become a liar? We can get into all that. Right? We just want to credit the prior statement to show all of the reasons why this one is more credible. You swore to tell the truth. It was closer in time to the event. All these details, right? and now you're changing your answer. All I want to show is that you're changing your answer. I'm not going to ask you when the day you became a liar. Because that is what I get to say in closing. And I get to tell the jury, it doesn't really matter which day he was lying, does it? Because now all we know is he's a liar. So we know at some point he's lying, at some point he's telling the truth. How could he possibly determine? Right? I get to say, Chris's testimony can't be trusted. So you want to, you got to remember impeachment is cross. So you don't ask that one question too many. We want to save that for closing argument. Okay? This is what you're going to come across much more often though. Impeachment by omission. Right? Much more common with social workers. I think I put a ridiculous fact in here. So what it says, credit the impeachment source that would have contained the statement had it been made. So, by omission means the social worker just got on the stand and said something that you're like, are you kidding me? If that were true, it would have been in a report. This is bullshit. So you want to credit the report that it's not in, that it would have been in. Okay? The key is the recognition that if the witness is now saying, if what the witness is now saying is true, that statement would have been made before, presumably in a document with which you are impeaching. So,
omission's a lot of fun, and I had a case in San Diego. It was a 366.26 case, and it got published, Jerome D. I don't know if it's still good law, I hope so, but because it was a good case. And what it was is the social worker did her 2-6 report, and it was just so lacking in everything. It was like a 12-year-old boy, and all of a sudden she decides that he has no bond with this mother who's raised him all her life, and so we're going to make another legal orphan. San Diego County was big about making legal orphans. I don't know how it is here, but they were 2-6ing kids all over the place. It was unbelievable. Anyway, I digress. So her report was just so lacking. I mean, she observed one visit in the time between the referral hearing, the 2-6, and the actual 2-6 hearing. She never talked to the foster mother's sister who had the child much of the time. She observed only one visit. And, how fun was that? Just go, ma'am, you filed a report, and in your 2-6 report, you said here that you only observed my client, or the mother and the child together at one time. She was having weekly visits, yes, showing, and you didn't talk to the sister, and you're aware the sister had this child about 60% of the time, yes, and you didn't talk to her about what she observed during the visitation between my client and the mother, and in fact, you didn't talk to, on and on down the line, and it was of course, the judge 2-6 my client and made Jerome a legal orphan, terminated parental rights, and it got overturned on appeal. And it was because the social worker did so little. And again, her claim that this child's not bonded to the mother, going back to experts and testimony. An opinion is only as good as the foundation that it's built on. And I was able to show on cross-examination that this social worker didn't do a thing. I mean, she really dropped the ball. And that's by omission. And as Kevin was saying, crediting that report. Well, you wrote a report, and you didn't put any of those facts in there. And the purposes of the report was to talk about bonding. And you really, just because it's not in the report, there's two. You can cross-examine what's in the report, but you can also cross-examine about what's not in the report. And that was my argument at the end. It's like this social worker has no basis for her opinion. They don't have a bond. She did little or nothing. She didn't talk to the foster mother once. She observed one visit out of 12. She, et cetera, et cetera. And so, I mean, cross-examining through omission is really powerful. So don't just limit to what's in the report, but show what's not in the report that's important.
Yeah. And I gave you guys a really obvious example. So we already did the traffic accident. The light is green. Here, social worker just testified on direct that she saw the mother smack the baby in the mouth during a visit 2 months ago. So that's pretty hardcore. But 2 weeks ago, the social worker filed her 6-month report. It didn't mention that. Let's say this is an A petition. If that social worker saw that mother slap a baby in the mouth That would have been the first thing in the report, right? So that's the point you're making. You're going to credit the social worker's report and say, look, this is a very credible thing, this social worker report. You know how important it is. You know the judge reads it, the judge relies on it, all the lawyers get it. The judge largely bases their decision based on the information that's in that report. You're statutorily mandated to create this report. There's all these things that you have to put in the report by law.
You're trained to write reports.
You're trained to write reports.
You're trained to write reports, and you're trained to put important information in those reports, aren't you? And in those reports, you put in important information because it can be used in a courtroom like this. Isn't that true? And in fact, you signed your report. And you signed that your report was true and accurate. And in that report, ma'am, not anywhere in that 14-page report, you testified on direct that you saw the mother slap the child. Not one time, in not one sentence in that report, did you put in there that you ever saw this mother slap the child? What's she going to say? Yeah, I did, or I forgot? Either way, it's not correct. If, yeah, I did, you hand her a report and let her point it out. Because you've been through the report, and you know it's
better
not in
be
there.
right.
Oh, yeah.
It's right here on page 8, dummy.
It's on page 8, 9, 10, and the first thing on page 1. So you want to make sure that it's not in there. But then if she says that she forgot, then it's not credible. Again, the credibility of the witness.
So you guys know all of this about social worker reports. So let's do a quick conga line. Can I get 4? Just 4. This will be quick. If you haven't come up here yet, especially you guys up front that are close to me, come on, come on. Come on, the longer it takes, we can't go to break. And the people in the back are complaining that there's too much air conditioning back there. I got one. I'm going to voluntold people. How about young lady in the first chair? Blue, head down, try not to make eye contact. Come on up. How about also you? Come on. All right. So I'll be your social worker. We're doing this fact pattern. I just testified that I saw the mother slap the baby. This is a baby. This is not Jason, the 12-year-old. This is a baby. I saw her slap the baby across the mouth at a visit 2 months ago.
Now, you just testified that you saw the mother slap the baby.
More incredulous than that. Was that incredulous? No. Be incredulous.
You just testified that you saw the mother slap the baby?
That was good. That was good.
Yes, that's what she slapped the baby.
Did you prepare a report dated November 3rd?
Yes.
And you were trained to prepare this report?
Yes.
And this report is statutorily required, correct?
Yes.
And this incident you just testified to happened allegedly on October 1st, correct?
Yes.
And you reviewed this report?
I wrote it.
And you are required to include important information in this report?
Yes.
And you certify that what you wrote in this report was true?
Yes. Let's get to some of the why. Why?
And
Why is
yet,
that important?
this report that you submitted on November 3rd did not include...
Let's not get there yet. Some of the why. What makes this... So, I signed it, I'm trained to do it, but why? Why is it important?
And you understand that this report is the primary piece of evidence that the judge is considering in deciding whether to continue family reunification services or terminate them or return the child.
Yes. What else about it that's important? Who else relies on it?
And you understand that all the attorneys are reviewing this report for its accuracy?
Yes. And what's supposed to happen?
And why would it be important to include all
Don't
significant
get me.
incidents?
No. You're on cross. Yes or no question. What was your question?
What was your question?
That the attorneys are reviewing the reports.
And so it would be important to include all significant facts in this report?
Yeah, I guess. Yep. Now I think we can get to the meat and potatoes.
So given all that, why would you leave out, no?
Because I got an explanation. I'll come up with something.
Was this incident of slapping in that report?
No. Yes. Actually, I changed my answer. Yes, it was. But you know damn well it wasn't.
Are we still
Go ahead, jump next.
Where in the report?
Yeah, there you go. If you better be right. But if she says, oh yeah, it's in there, go, yeah. May I approach you? Show me where. Okay. Oh, I can't find it in the report.
A child being... No more questions.
So we don't want to get her to agree that that's a big fact that you should have put in your report. That's what the whole case is about, physical abuse, and that's the thing you leave out of your report. You don't ask her that crap. You get her to admit that the report is required. It's mandated by statute. We all rely on it. You put the important shit in there. You've been trained to do it. You've been doing it for 10 years or whatever. And then in closing you go, and then she comes up here and tells us that she saw the mom slap the baby and she didn't bother to put it in the report? I mean, that's crazy talk. You know, so we know one of two things. Either that didn't happen, or, you know, she's an incredibly incompetent social worker who doesn't inform the court. You know, 'cause what if I didn't set it for trial? The court wouldn't know.
People want to look good. I don't care what you're doing. They don't want to make themselves look bad. So you're not going to have a witness who says, you know, well, you know, my report's garbage. So that's why I didn't put it in there. That's not going to happen. I mean, you want a job Monday morning? You're not going to go up and say that. So you kind of know where people are going. The other thing is when something like that is so lacking, don't give them any explanation as to a chance to explain why it's not in there. You just, why give them that chance? The fact is, it's not in there, you didn't put it in there, and that's a huge significant event, because what you've already done is you've cross-examined them on how important it is. Not only is your report important, you know it's going to get submitted to the court. You know that people are going to rely on it. You know it's going to be used in a courtroom like this. You were trained. You know how to write reports. Not only do you write the report, you review them. And before you review them, you signed it. And you signed this report. And nowhere in this report is there that this incident, that the mother slapped this child. I mean, you know, really locking him in. So.
And county counsel's going to come in and try to give her a chance to explain, but the damage has already been done, right? So don't worry about that. I have 2:45 exactly. It says we're supposed to take a break. Go take a break. Because I just told you, like,
you don't represent the client.
No,
you said that. No, that one's
maybe like 3 weeks ago.
Hello. Hello.
You go ahead.
I know.